Good morning. Are you Demarcus Elam?
Yes, ma'am.
And this is cause number 26, DCCR 1221. Mr. Elam is charged with the first-degree felony offense of murder. And Mr. Reynolds was appointed as attorney. Ms. Holmes is stepping in to help out on that as well, and they have filed a writ requesting for a reduction in Mr. Elam's bond, which is currently set. Oh,
Yes.
oh,
Yes, I believe Mr.
did I
Elam.
know that ahead of time?
Okay. He was on the book. And he- I'm sorry if I didn't make that clear.
No, I guess not, because I'm not gonna, so here's the thing, when you have an attorney, you don't get to have what we call dual representation. So if you, and I don't mind,
I think if I could clarify, it was filed pre-indictment. I'm not sure when Mr. Reynolds was placed on it, but Mr. Elam had filed the writ prior to being indicted, and then after the writ was filed, his case
was indicted.
So
So it's been indicted at this point.
yes, ma'am.
Okay. So here's what I'm going to do. What's the bond currently set at?
2 million.
Okay, so what I'd like to do, I'm not going to, because the case has been indicted. At this point, a writ is probably not the appropriate, tool. I would think it would just be a motion for a bond reduction. Ms. Holmes can talk with Mr. Reynolds. They can get that filed. They're going to file things on your behalf, okay? And so I understand that you were waiting on an indictment but that's been taken care of now, but you don't get to file something if you have an attorney. I'm gonna take what they filed. So let's get a bond reduction. Ms. Holmes will get that filed for you. I'll reset the case 1 week, but I think we need to have the appropriate tool moving forward legally. Let's do 2 weeks, and we'll have a bond hearing. If the state has any evidence, that'll give them some time to bring anybody, if you wish, on a bond reduction hearing. Okay, so we'll see you back in 2 weeks.
Okay.
Right, ma'am, are you Kashonda Riley?
Yes, ma'am.
And so we've got 3 cases here for sentencing. Cause number 24, DCCR 1778 is a motion to revoke probation. Ms. Riley is on probation for theft of property with previous convictions. Entered pleas of true in that case. Let's see which counts.
I believe 1 through 5.
1 through 5, thank you. And then we've got 2 new cases, 26 DCCR 0210 and 0211. Ms. Riley entered pleas of guilty in each of those, which are theft of property with previous convictions. The agreement on all of these was for a cap of 15 months in the state jail prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
Not from the defense.
Nothing from the state, Your Honor.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. I know it's a big ask, Judge, and it's not something that the court, I think, probably is leaning toward, but we're asking the court to consider probation in all these cases. Ms. Riley is 27 years old. She's got 2 young kids at home. As you can see from the PSI, most of her previous offenses are theft or some type of deception cases. And certainly she's old enough to know better. She should know better. I think if you look closer at her background, it's a situation where she never really had a chance to get any kind of direction in her life. She was placed in the CPS custody when she was 3 months old. I think she lived with her aunt until she was 14. I think all that time, or most of that time, her mother was in prison. And when her mother got out of prison, Ms. Riley went back to live with her mom. From 14 to 17. At 17, she ran away from home. And I think the father's in prison now. I don't know how long he's been in prison, but he's in prison now. I think the easy thing to do is to go ahead and send her to the state jail. Not only for the court, the easy thing for Ms. Riley would be to send her to the state jail so that when she gets out, her slate is clean. She starts all over. I don't know that that's going to, I think if that happens, Judge, she's probably going to be back in the same place she's at, committing offenses, committing more thefts. What I'm asking the court to do is consider probation. with possibly ISF, the cognitive track of ISF, so that she can get some direction, hopefully start learning how to make better decisions, and get her life onto the right track. And I think, do you want to say something to the judge? At the appropriate time, she wants to say something.
Go ahead.
No, I have had time to sit and think about my consequences. I wanted to I have talked to my aunt that I was staying with at first. She said that I could come back and stay with me and my 2 children. She's willing to help me try to get a GED and to get into the infirmary and the plant, like the refinements. So
You need to look back. The NTRP case for me. How long she sent? All right, Mr. Nichols.
Judge, I think the 15 months is appropriate in this case. Her misdemeanor history is incredibly extensive, lots of thefts, lots of probations that have been revoked. And if you follow the timeline, it's for committing thefts while on those probations, which is what she did here. Two new thefts, 6-7 months after being placed on probation for theft. So I think given her criminal history and continuing to commit crimes while on probation, I think 15-month state jail is appropriate.
Give me just a second. I want. Yeah. And if that's not easy to find, then.
What's the question, Ron? I don't know.
To this case?
No, I'm wanting to know, and it's not really going to make a big difference, but she said she's had time to sit and think. And what I wanted to know was how long she had to sit and think before she took the probation on the case she's on right now.
I can go back and look it up if you need it.
But so Miss Riley, you were on probation. You've had 1, 2, 3, 4, 5, 6, 7 probations. 7. You were given a probation for this felony, and 4 months later, you picked up 2 new theft cases. You've had every opportunity for whatever help it is that is out there. It's not like you've just taken time and not had opportunities with probation to help you. And so at this time in cause number 24 DC, excuse me, 24 DCCR 1778, I'm going to find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 26, DCCR 0210. Find that you pled guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 26, DCCR 0211, find sufficient evidence to find you guilty of theft of property. Find you guilty of that offense, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, so you waived your right to appeal.
This courtroom
I also
moment shows
handed
how
you-
critical legal procedure can be, especially in serious cases like murder. The defendant attempted to reduce a $2 million bond, but the judge quickly pointed out a key issue. The request was filed incorrectly. Since the case had already been indicted, a writ was no longer the proper legal tool. Instead of considering the reduction, the judge denied the request and instructed the defense to refile it properly. It's a reminder that in the justice system, timing and legal accuracy matter just as much as the argument itself. For now, the defendant remains behind bars, waiting for another opportunity to request bond. The next hearing could determine whether he gets a chance at release or continues to face the full weight of the charges.